All right, it looks like we are streaming and recording. We had a bit of a technical issue this morning, but I think we are ready to move forward. So at this time, we are on the record, and I am calling the evidentiary hearing to order. My name is Andrew French. I'm chair of the Kansas Corporation Commission, serving as presiding officer for the hearing, and I'm joined by my fellow commissioners Dwight Keene and Andy Keither. This is docket number 23, CONS 3345 CPEN, and it's captioned in the matter of the failure of Haas Petroleum LLC to comply with KAR 823-120 and KAR 823-133 by operating under a suspended and revoked license. We will begin today's hearing with the entries of appearance, and I'll start with commission staff.
Good morning, Chair French, and thank you, Commissioners. Kelsey Marsh on behalf of Commission staff and the public generally.
Good morning, Mr. Marsh. And Operator Haas Petroleum?
Good morning. Operator Haas Petroleum appears by its attorney, Keith Brock of Ottawa.
Good morning, Mr. Brock.
Good morning.
Let's now move to notice of this hearing. Does staff have a recommendation regarding notice?
Yes, notice of this hearing was provided in the presiding officer's December 29th order setting evidentiary hearing for Thursday, February 8th, 2024, beginning at 9:00 a.m. via the Zoom video conferencing platform. The presiding officer's order was properly served on the parties. I would also note that Haas's counsel and witness are in attendance. Staff's recommendation is that notice is proper and the commission has the jurisdiction to hear this matter at this time and place.
All right. Are there any objections to notice?
No.
Hearing none, and based on staff's recommendation, I will then find that notice is proper and the commission has jurisdiction over this proceeding at this time and place. We will now move to some preliminary matters. I'm going to run through my normal list of preliminary reminders about the fact that we're doing this over Zoom and how we're going to handle any issues if we have those, although everybody's already probably versed in that by this point in the morning. But if we encounter any more technical issues, please just ask to go off the record. We can recess at any time, resolve those technical issues, and then we'll go back on the record. Second, because we're doing this on Zoom, we ask everyone to keep your microphones off or muted when you're not scheduled to talk. And if everyone would also please mute your cell phones or your office phones, other electronic devices, that would be very much appreciated. Third, so the parties are aware, if the commission needs to consult during the hearing among ourselves for something like an evidentiary ruling, we will go off the record and we will enter into what's called a Zoom breakout room to discuss that before we come back and go back on the record. Fourth, since we're doing this over Zoom, we're not all in the same room together. Please be very deliberate about identifying exactly what you're referring to when you're discussing pre-filed testimony or exhibits. We do have copies of all of that on hand, so we should be able to follow along if you identify what you're speaking about. So with that, do the parties have any other preliminary matters to take up at this time? Hearing nothing, we will move on to the hearing itself. In regard to the procedure for the hearing, parties are typically allowed to make opening statements. After opening statements, we will have examination of the witnesses. After direct examination of the witnesses, there will be an opportunity for cross-examination and commissioner questions and redirect. Any further examination, for example, recross, would be at the discretion of the commission. Following witness examination, we will allow closing statements and arrange for the filing of post-hearing briefs if necessary, and then we will conclude the hearing. Let's begin with opening statements. We will begin with Mr. Marsh.
Thank you, Chair French. May it please the commission. There's a pretty extensive recent history of violations committed by Haas Petroleum that has led to the docket before you today. I just want to give a brief summary real quick. Commission held a hearing in October 22 regarding violations that occurred with Haas's wells. In November 22, the commission issued a final order affirming several penalty orders at issue during the October hearing. This final order also denied Haas's application for license renewal. Commission staff later suspended Haas's license on December 28th, 2022, due to its noncompliance with the commission's orders. The commission later issued an order that stayed Haas's license suspension through February 6, 2023, but that order also stated that any illegal operations beyond February 6th may be penalized. On March 24th, 2023, Commission staff conducted various inspections of Haas's leases and found 10 wells under its license in operation. Each of these 10 wells are identified in the shut-in order and were listed under Haas's license at the time of inspection. On June 6, 2023, the Commission issued a shut-in order to Haas Petroleum, assessing a $50,000 penalty for operating wells on an expired license. Staff requests that the Commission's penalty order be confirmed. Thank you.
Thank you, Mr. Marsh. Mr. Brock, do you have an opening statement?
I do. Thank you, Mr. Chairman. I decided I had a little bit of trouble deciding what I wanted to cover in my opening statement. And ultimately I decided that the Commission needs a complete picture of what's happening here, the context in which we're appearing, and the effect that various things are having on the Commission. And in order to do that, I decided that I would start more broadly than I normally would. And some of these things are housekeeping, and I know that you'll agree with them and already know them, but I just want to cover them to just to put us in the correct posture. So as the state agency, the Commission is tasked with regulating this industry in three very unique ways: through rulemaking, through enforcement actions, and through adjudication. And that's, we all agree with that, we all know that. But in this system, it's very important that the staff, in the context of field staff, and in these cases, in these penalties, maintain their role as enforcement. Whenever they begin to try to engage in rulemaking through adjudication or the enforcement, the entire process becomes confused, and it results in desperate treatment among various operators. It results in an unfair burden on the regulated because they have to defend various actions that are not just purely enforcement actions. And then finally it results in non-uniform and harmful adjudicative decisions by the Commission. And so I just wanted to paint that context. In this particular case, this is a penalty case. In this context, the analogy is very simple. The Commission field staff are the police. The Commission legal staff is the prosecutor. They're the legal experts. They're tasked with enforcement, interpreting the law. Then obviously you're the judge. But what's happening here is that the staff is trying to change the law and what it says. And there has been a process of that, and that's resulted in some harm. And so I wanted to point that out to let the Commission see it, try to paint a clear picture of it. In this case, as a penalty docket, the Commission's role is to enforce the law as it's written and ensure that it's applied fairly and uniformly, and that all constitutional provisions all constitutional rights are protected. In my view, one of the best indicators of how well a government does at doing these things, at maintaining this separateness, is how they treat those that they disagree with or that they don't necessarily like. And I think it's really clear from the history that Haas Petroleum is definitely an operator that they didn't agree with and perhaps don't necessarily like. And so I think that context is important. To paint the picture, in the prior docket that was before this Commission, there was a consolidation of various dockets, but it was 22 CONS 3099 was kind of the, I don't know whether I want to call it the pilot docket, but that's the one that all the filings were made under. In that docket, there were various UIC violations, injection violations, and those weren't in dispute. The issue there was just how much grace the Commission wanted to afford. But also brought to light in those dockets were some other issues that the Commission did not have to address directly. Those issues were that once these UIC violations happened, the staff engaged in certain activities to try to ensure that Haas Petroleum's license was taken. Among those, the Commission received evidence that 1,064 wells were added to Haas Petroleum's operator's license, not in accordance with Kansas law and in violation of 55-179. The commission also received evidence that that Haas Petroleum received notice to shut down 116 of its injection wells simply because they were within a quarter mile of an abandoned well. No other operators in the industry received that, but Haas Petroleum did. They also received evidence that all transfers of wells from Haas Petroleum to any other operator had not been approved for a period of over 2 years. The commission also received evidence that Haas Petroleum's access to the COLAR filing system was shut down so that it couldn't continue to make filings it was required to do, couldn't monitor its deadlines and all, and those types of things. In that order, the commission limited its order to only the UIC issues. And from a legal perspective, that was appropriate. I'm not here rehashing the prior docket, but the context is important. But what the commission didn't do, either in the order or after it, was address these other issues with staff to make sure that there was uniform enforcement, even if we didn't like the operator, that there wasn't any desperate treatment. And so that's resulted in what we're here on today. Today, we have a very direct question of that, and there's not any peripheral UIC issues involved. And so that's why we're here in this hearing. So what is this docket about? In that prior hearing, the commission ordered Haas Petroleum to shut down all operations effective as of February the 6th, 2023. The evidence that the commission is going to receive is that Haas did exactly what they were ordered to do. After February the 6th, 2023, Haas Petroleum had no field employees, produced no wells, turned no wells on, plugged no wells, pulled no wells, any of that. What this docket is about is on February the 1st, Haas Petroleum transferred the 10 wells that are at issue in this docket to a separate entity called BHD Resources, LLC. They filed T1s for that transfer on February the 3rd. Nearly 2 months later, on nearly 2 months later, on March the 24th, staff inspected these 10 wells and possibly others, but they found that BHD Resources was operating these wells. Every staff report that's attached to the penalty order in this docket says that BHD was found to be operating them. Every field report that's attached to the penalty order in this docket shows that staff contacted BHD Resources and instructed them to shut them down, not that Haas Petroleum wasn't contacted at all. And then finally, the evidence is going to show that in docket 23 CONS 3343, the commission found in what ended up being a final order that BHD Resources was operating these 10 wells that are at issue in this docket on February the 24th and fined BHD $10,000 for that. These are the same wells on the same day that's at issue in this docket, but yet we're still here on a hearing to fine Haas $50,000 because BHD was operating these wells. Every operator in the industry, when a lease is transferred, the new operator takes over. The commission doesn't penalize past and prior operators. Regardless of the interpretation of the regulations, that practice is not uniformly enforced. It's only being done to Haas Petroleum. That's desperate treatment. The regulations that Haas Petroleum is accused of violating are basically that it illegally produced oil, but the evidence will show they didn't produce anything. BHD operated certain wells as the commission's order and the other docket found. It's going to show that the second regulation requires an operator to have engaged in drilling, completing, servicing, plugging, or physical operations. Haas Petroleum did none of those things. Those are the two laws that are at issue here. But despite all this, Haas Petroleum is still being targeted for this exceptionally large fine. I hope that context makes sense in light of all this, but that concludes my opening statement.
All right. Thank you, Mr. Brock. This does bring us to the witnesses. And I think we can start with staff. Staff, you may call your first witness.
Thank you, Chair French. Commission staff calls Julie Schaefer to the stand.
Good morning, Ms. Schaefer.
Good
All right.
morning.
Good morning. We do not have a court reporter with us this morning, but we are recording this, that means I will need to swear you in. So if you would please raise your right hand. Do you swear or affirm that the testimony you will give today is the truth, the whole truth, and nothing but the truth?
Yes,
All right, thank you. Mr. Marsh, your witness is yours.
Thank you, Chair French. Can you please state your name for the record?
Julie Schaefer.
Ms. Schaefer, by whom and in what capacity are you employed?
I'm employed by the Kansas Corporation Commission Conservation Division, the District 3 office in Chanute.
And what is your work address?
It is 137 East 21st Street, Chanute, Kansas, 66720.
Are you the same Julie Schaefer who caused to be pre-filed in this docket direct testimony consisting of 6 pages on August 4th, 2023, and rebuttal testimony consisting of 3 pages and 1 exhibit on September 1st, 2023?
I am.
Was this testimony created by you or at your direction?
Yes,
Now that you are under oath, do you have any corrections to make to your testimony?
I do not.
If I asked you the same questions contained in your testimony today, would your answers be the same?
Yes,
Do you swear the answers contained in your pre-filed testimony are true to the best of your knowledge?
yes,
At this time, staff moves for the admission of Ms. Julie Schaefer's pre-filed direct and rebuttal testimony into the formal record.
Is there any objection?
None.
Hearing none, the reference testimony will be admitted.
Thank you. At this time, staff tenders the witness for cross-examination.
All right, thank you, Mr. Marsh. Mr. Brock, do you have any cross?
I do. Thank you. Good morning, Ms. Schaefer.
good morning.
Would it be okay if I share my screen? I think the commission has it's just the penalty order in this docket that I'd like to display on here.
Yes, go ahead. And we see it. If you could maybe zoom in a little bit, that would be good.
How's that? I can't see what you're seeing. My
That looks pretty good to me, unless I hear differently from anyone else.
Ms. Schaefer, can you identify what this is?
It is a shut-in order ordered by the commission.
And would you agree that that's the order that's at issue in this particular docket that we're here on today?
I believe so. It's those two, 82-3-120 and 82-3-133.
Thank you. I'm just going to scroll toward the end. These are the field reports, and you were part of the team that investigated these. Is that correct?
That is correct.
So just to kind of walk through that, the person that was contacted after you inspected these wells, Ben Harrell, owner of BHD Resources, do you see that?
I do see that.
Do you see any reference that Oz Petroleum was contacted after this inspection?
I do not, excuse me, I do not see that. Potentially an oversight. I did not personally make any contacts, but I was with Mr. Dooling when he made those, and he did try to call Oz Petroleum first. And there was no answer. Did not get relayed in there. I do see.
In these findings, there's a note where Ryan had tried to call or had contacted Ben Harrell with BHD Resources. Can you just tell me just reading that, can you just summarize what this is saying?
That he had tried to contact Ben Harrell and he did not answer, so he left a message. And then I believe he returned his phone calls.
Um, so once he talked to them, he told Ben Harrell that the lease was still supposed to be shut in. And then this last line says, Mr. Dooling explained to Mr. Harrell that the leases BHD resources were acquiring through the transfer were supposed to be supposed to remain shut in until the transfers were approved. Then just summarizing this, I don't want to spend a lot of time, but would you agree that staff contacted Mr. Harrell, told him that the leases had to remain shut in? Mr. Harrell, the president of BHD, then shut in the leases?
I would agree with that.
And then in conclusion, the conclusion of this field report is BHD resources have been operating this particular well. This last paragraph here.
Yes, that's what it states.
And no finding that Haas Petroleum had conducted any operations or operating any well in that report. Is that correct?
We did not see anyone out on the leases that day, correct? Per our wells database, they are still listed under Haas Petroleum's license.
If we can shortcut this a little bit, even under these reports, the operator's listed as BHD resources, correct?
Correct.
This is the next well. I'm not going to go through each one of them. We can shortcut it, but if you look at the conclusion, it's the same. BHD resources was found to be operating this well. Would you, in the interest of time, would you agree that every one of these reports found that BHD resources was found to be operating these wells?
I believe that's what Mr. Harrell stated to Mr. Dooling. Yes.
And would you agree that none of these field reports have any findings that Haas Petroleum was operating any of these wells?
They do not indicate that.
Thank you very much.
Mm-hmm.
On page 5, line 20 of your testimony, you don't necessarily have to refer to it because it's a quick question, but it looks to me like you agree that these wells had been transferred to BHD and that T1s were filed with the commission. Is that correct?
The request for T1 transfers had been filed to BHD. They had not been approved.
And so the entire basis for the $50,000 penalty is that it's staff's contention that because the T1s hadn't been approved by staff, Haas Petroleum should be fined $50,000 because BHD operated the wells. Is that fair?
I would say that was probably fair.
Okay. I'm gonna share my screen with, or I'm sorry, the screen's already shared. I'm just gonna open the BHD penalty order that we'd asked the commission to take administrative notice of. This is docket 23 CONS 3343 CPEN.
Objection? We'll take notice.
You got really quiet for some reason, Chairman. I couldn't hear what you said. I'm sorry.
My apologies. Is there any objection to notice of this document?
No.
The commission will take administrative notice of it.
Ms. Schaefer, would you agree that the wells that are at issue in this docket, this BHD resources docket, are the same exact 10 wells that are at issue in the Haas Petroleum docket we're dealing with today?
I am unsure of that.
So I've scrolled down. These are the well names and API numbers. If we need to compare those with the penalty order, we can. I can scroll down with these if you want me to.
No, that's fine. Yeah, they appear to be the same wells.
Okay. And March 24th of 2023, that's the same date that you conducted that inspection that's at issue in this Haas Petroleum docket, correct?
Correct.
And so it appears that after staff conducted a field investigation, they procured penalty orders against two separate companies, alleging that both companies had operated these wells unlawfully. Would you agree with that?
Yes.
And since this order became the final order in the BHD Resources docket, would you agree that BHD Resources was fined $10,000 as the result of that?
If that's what it was, yes.
So the regulations that are at issue in this particular docket, KAR 82.3.133, basically prohibits an operator from producing oil in violation of a regulation. Do you have any evidence that Haas Petroleum physically produced any oil?
I don't have any. We have on record, the sales of oil, past the February date. Who sold that oil? I mean, those leases are still attached to Haas's license, so presumably it was them.
But when we referenced the field reports earlier, isn't it true that BHD acknowledged that they were operating them and they voluntarily shut them down on that day?
They did. Those wells were not on their license, though.
So in terms of physical production activities, do you have any evidence that Haas Petroleum conducted any of that on these 10 wells after February the 6th?
Like I stated before, we did not see any individuals out in the field that day that were pumping or anything. So no.
Okay, thank you. The second regulation that Haas Petroleum is alleged to have violated is 82.3.120. It basically says that no person shall conduct any of the following operations without an operator's license. First is drilling. Do you have any evidence that Haas Petroleum conducted any drilling after February 6, 2023?
No.
The second is completing. Do you have any evidence that Haas Petroleum conducted any completing activities after February 6, 2023?
There were a couple rigs set up on a couple leases, so there was some kind of completion work being done.
And do you have evidence that those were Haas Petroleum's rigs?
I do not. I'm not for sure. I believe we tried to make note of the rig license, but there was none on it.
And I guess just to plow a little bit of the same ground, but isn't it true that you called BHD about those operations and they acknowledged conducting the work and shut them in voluntarily?
Yes.
So would you have any reason to believe that those completion operations were being conducted by anyone other than BHD Resources?
Only that those wells were not on their license yet, so
Okay.
they could have been at Haas's direction.
The next one is servicing. You have any evidence that Haas Petroleum conducted any servicing operations after that?
Just what I just spoke about.
Okay. And plugging, would it be the same response to that?
Did not see any equipment for that.
And physical operation, would the response be the same to that?
Correct.
And would you agree then, just to summarize it all, that you have no evidence or information that would indicate that Haas Petroleum conducted any physical operations after February 6, 2023?
Just what I've spoken of.
Okay.
Wells were currently pumping and they were still under their license.
Thank you. So in this industry, transfer of wells and assignment of leases is fairly common. Would you agree with that?
Correct.
And in your experience, when a lease is assigned, does the new operator generally begin operating that well immediately after it's assigned, or do they wait for the commission to approve the T1?
I can't really speak to that. I am not, my job descriptions don't include transfers, approving transfers.
Are you aware of any instance at all where the KCC penalized an operator for beginning to operate a well before the T1 was approved?
I am not aware of any. Like I said, I don't do that in my daily activities.
Besides this particular docket that we're involved with, are you aware of any instances at all where an operator that has assigned a well has been penalized any amount of money because the new operator took over operations before the T1 was approved?
I am not aware of any.
Certainly not aware of any that received a $50,000 penalty then, if you're not aware of any at all.
That's what that would mean. Yes.
I'm going to display one more penalty order. The reference to this one, I'd like the commission to also take judicial notice, or I'm sorry, administrative notice of, is docket 24 CONS 3006 CPEN.
No objections.
All right. We will take notice of that order.
So all that I want to do with this docket is really show what the present docket is not. Would you agree that this penalty order in the 3006 docket imposes a $500 fine on Haas Petroleum because they had wells on an expired license or a revoked license? Would you agree that that's what that penalty docket is?
I believe so.
So I'm just wanting to be clear, that's not what we're dealing with here. That's a separate issue, separate docket, and that's a $500 penalty, correct?
I'm not familiar with that, so I don't know what all that was for.
Do you need me to scroll down to this, or would you have any reason to disagree with that? I can scroll down through the docket.
Mr. Brock, could you zoom in a little bit? I
Yeah.
don't know if that's readable for everybody.
I apologize. Every time I
worries.
open a new one,
That's much better.
paragraph 10 would be your applicable one that would.
Correct. Yeah.
So the subject of that docket is that Haas Petroleum had wells on its on its license after it was revoked, correct?
That's what it appears.
And so the docket that we're dealing with today is specifically a $50,000 penalty because Haas Petroleum is alleged to have operated these 10 wells after its license was revoked. Is that accurate?
I do any part of the penalty orders, so I mean, yes, that's what it's about, but I'm not sure on the reasoning for the amounts or anything.
Understood. Just real quick, and just to make a point about the effect of these orders. So in this particular order, wouldn't you agree that it's required that operators shall shut in these wells, and then if it remains for another 30 days after that, then, or I'm sorry, 60 days after that, then staff shall revoke injection authority? Would you agree that's what that says?
I'm going to object here just because I think this is outside the scope of Ms. Schaefer's testimony.
I'll let the witness answer to the extent she can.
I mean, reading what is written there, yes, I see that, but I don't know at what point in this penalty order was given.
Okay. And I promise I'm not going very far with this. I just have two questions about it. Um, this one doesn't have a certificate of service. That other docket doesn't have a certificate of service. So what I've done is switched back. You can see this is the penalty order in this docket.
Heath, I think the certificate of service is at the very bottom.
Behind the exhibits.
Yes.
Okay, I thought I saw it earlier. So this order went to Nancy Bors, Kelsey Marsh, and Mark Haas, 3 companies. This is my last question on this subject, but I just want to make one point. The wells that were assigned to BHD are listed on these, along with about 1,000 other wells that were assigned to other operators. And because staff hadn't approved the T1s, would you agree that an order was issued that would have required all those other wells to be shut in and their commission and their injection authority revoked without having given any of them notice of the proceeding?
You're gonna have to repeat that because I'm not sure I'm following. Are you talking about the 1,000 other wells that you just mentioned, or what are you speaking of?
So the ones that you can speak to in this
Mhm.
particular case are the 10 wells that we're dealing with that had T1s filed to BHD Resources. I've just purported to you that there are 1,000 other wells on this list that were assigned to other people and T1s filed, but you can only speak to the 10 wells to BHD. Did BHD receive notice of this penalty order?
I would not, no, I mean, according to that, no, they did not. I mean,
But this order would have resulted in an order to shut in those wells and to revoke injection authority, and BHD didn't even get notice of it.
why would they have if that's dated July of 23 and their T1 wasn't it like February, or I guess that was February. I am unsure, sir.
And in this particular docket, the only point that I wanted to make is the same thing. BHD is not on this one either, nor is any other operator, correct?
I would assume it's just because those wells were not on their license yet.
Okay. And that's exactly where I'm going with it too. Because of this process of not transferring wells until the staff has approved them, the people who have ownership interest in these wells didn't receive notice of either of these dockets before an order would have been issued requiring them to shut in and take their authority granted by the commission. Is that correct?
That's what it appears.
Okay. I know that was a little that was a little bit outside, but I appreciate you bearing with me with that. Thank you very much for that.
Yes.
Those are all the questions I have. I really appreciate your answers and bearing with me through that process. I know there was a lot of jumping back and forth. I'm gonna turn off my share. Do I push new share? I'm really sorry. I don't know how to make it stop.
I think you
Stop
can
share.
just hit, there you go.
I
There you
got
go.
it. I'm sorry.
We've got everybody back now. All right. Thank you, Mr. Brock. We will turn now to commissioner questions, and I will begin with Commissioner Keen. Do you have any questions for Ms. Schaefer?
Yes, I do, Mr. Chair. Good morning, Julie.
Good morning, Mr. Dwight.
Just to embellish a bit more your background and your current position, am I correct in that you are the district geologist for KCC District number 3?
Yes, sir.
Okay. Julie, it appears that you're going to be the only staff witness in this hearing. Is that correct?
That's what I believe, so yes.
I have a number of questions for staff that I believe are relevant to the ultimate determination in this matter. So if I ask or inquire about any matters that are beyond your knowledge, please do not hesitate to state that that is the case.
Okay.
Just for purposes of clarity and for an overview for benefit of the commission, what, for the record, is the purpose of the Form T1?
It's to request a change of operator.
Okay, that would be from one operator to another, the totality of the regulatory responsibilities, essentially. Am I paraphrasing that closely?
Yes, correct. Yep.
Okay. Help me out here, but I can't find in the record, as I see it before us, where are the T1s that are relevant to this matter? Are they here?
I'm not aware if they are in this information that I have.
Well, I looked at some of the supplementary information that was provided by the staff that we didn't see until this morning, and I don't see the T1s or that are germane to this case that were there. That's why I was asking. Let me proceed. I think it's been pretty much testified to in a number of ways from yourself and Ms. Epps. I think that what's on the record right now, that whatever, well, let me back up a little bit, Julian. I'm trying to be fair in what I'm just trying to figure out what's going on here. Part of what was actually filed this morning, and I'm not sure, John, if you can find it. You can screen share it. It's this letter under the Haas Petroleum letterhead to the main office there in Wichita of the commission. The letter itself is dated February 1st, and it was received by the commission central office on February 3rd, signed by Rhonda Epps on behalf of the operations division of Haas. Do you have that, John?
Probably. Give me a moment.
It's in part of what was supplementary filed this morning.
Yeah, it looks like you're referencing potential staff cross exhibit number 1. I'm going to pull that up in a moment here. Is this what you're referencing? All right.
Yeah, that is it. Julie, can you see that?
I can.
Okay. Let me kind of just put the final touches. I don't mean to dwell on this either, believe me, on this, but again, beyond this, do you know whether there was a Form T1 filed evidencing a change of operator from Haas to BHD Resources?
I believe it's probably attached to that. There.
Hey, yeah, thank you. Well, I stand corrected. There it is. Or rather, let's see, let me check it out here. There they are. Yes. Okay, very good. We can take another screen share, John. Thank you. Now, my question, follow-up question to you, Julie, is this, and again, if it's beyond the purview of your knowledge, please state that. Why were these T1s not processed by the central office or by the KCC?
That is definitely something that I would not be able to speak to. I do not do any job responsibilities that include anything to do with transfers.
Okay. Let me go back and do a little backfilling on some of the line of questioning that Mr. Brock had directed to you. And so what I'm asking for you, from you, if, to the extent you know it, is in the staff's view, what consequences in terms of transfer of ownership do lease assignments, operating agreements, and other lease legal documents beyond the T1, including any documentation or transfers to first purchasers? To what extent do these assignments transfer responsibility and ownership and control over oil and gas leases and wells? I know you're not an attorney. I know you're not
I
an
was gonna
attorney.
say, that would be something that I assume our legal department looks over when those transfers come in, and so I'm sure there are several steps that are taken, not only with the EP&R team that reviews the T1s, but then it probably goes to legal to make sure all the additional documentation is available and ready and correct.
Fair enough. So basically, in the scheme of the legal documentation, I'm going to guess that I'm going to guess, and you correct me if my guess is wrong, that the staff considers an integral part of that to be the filing of the T1
Correct. I would
to
say
make the transfer complete as
to
far
make
as
the
the legal.
transfer. Correct.
Yeah.
Right.
And what that brings me back to once again is the question: why weren't the T1s processed? We have nothing on the record that I can find that shows that. Can you point to something that shows that?
I cannot. I do not know the status of what was the holdup.
Okay, let me ask you a couple of follow-on questions. It's highly probable that you won't be able to answer these too, in fairness to you. From the staff's perspective, do you know whether the transactions between Haas and BHD that led up to the filing of the T1s were at arm's length?
I would not know or be able to speak to any of that. I do not even know what the condition on any of the compliance issues were. It was my understanding that there were still compliance issues from the original dockets and orders, so potentially that could have been some of the problem.
Fair enough.
I'm not.
No, I didn't mean to interrupt you, Julie.
No, I was just going to say can't speak to that because I don't have that knowledge.
Fair enough. A related question, and my final question along this line is, from the staff's perspective, were the parties attempting to evade the application of any commission rules and regulations through the transfer?
Were the KCC trying to evade? Is that
No,
what
no,
you're
no,
asking?
no.
Sorry.
No, let me restate it again. To the best of your knowledge, if you have knowledge, from the staff's perspectives, were the parties attempting to, that is the parties that would be Haas and the BHD, the two parties to the T1, were they attempting to evade the application of any commission rules or regulations through the transfer? To the extent
Nothing to my knowledge.
Okay. One final line of questioning, and I'm finished. I'm looking now at your rebuttal testimony, Julie, and the attachments to that. And John, what we might do for purposes of simplicity, because I'm going to kind of follow the pattern Mr. Brock did, we use one example and see if it doesn't apply to more than one circumstance, so that we don't want to be repetitive here. If you could bring up, let me find what I'm looking for here. Were you able to find what I'm referring to, Julie? You have it before you.
I do have it before me, correct?
Yeah. Bear with me a second here. Yes, John, if you would, turn back to the exhibit. Let's start with page. It's exhibit JS1, page 1 of 20. Yes, that's fine right there. Can you see that, Julie?
I can.
Correct me if I'm wrong, but I believe this page was taken from the Kansas Geological Survey website, was it not?
It was.
And drilling down a little more specifically, what this tries to evidence is by operator a production record, or yeah, we'll just leave it at that, a production record. Is that correct?
That is correct.
Okay. And in this instance, here's one question I had about this and the other documents that are similar to this that are attachments to your exhibit, to your pardon me, your test, your rebuttal testimony. Do you remember what is the date that you took this down? What would be the date of this as it was taken from the survey website? Do you know?
Most likely it would have been about 3 months past March. So approximately probably June.
June of 23.
Correct, probably.
Okay, fair enough. If we could then, John, let's turn to, and you can follow along with a hard copy there, Julie, make it easier on you probably. Let's turn to, again, let's see, let's turn over to, again, exhibit JS1. It's page 5 of 20. Just scroll down a little bit. That's fine right there. This is the last page, I believe, Julie, if I'm fairly portraying this, of what you took down from the survey website that applies to the buried lease.
That is correct.
Okay. Now, if we look down at the very bottom, doesn't it say that as of the date you took this down? Well, first of all, let me talk about what this portrays. Let's look at the bottom 3 lines, if you will, which evidence something for 2023 for months 1, 2, and 3. Do you see that?
I do.
Okay. Let's take the third line up from the bottom where it shows 2023. It appears it's for January. Would that be correct?
That is correct.
And it shows a barrel amount of 250.14 barrels, does it not?
It does.
Now, does that represent the production for a given month, or does that represent sales?
That is what was sold to. At that point, it was Coffeyville Resources.
Okay. So the actual production itself could have been prior to the January date, could it not? It was just that the sales occurred in that month.
Correct.
Yeah. And I think that's exactly what it does portray. Let me just offer as an aside here, I think one part of the significance of what this captures is, in terms of its accuracy, is that much of this information is derived by the survey from information provided by the Kansas Department of Revenue, is it not?
It is.
And that's incidental to their levying severance tax, if applicable, or other taxes such as the conservation fee and other matters. Isn't that correct?
That is correct.
Okay. So basically, I'm going to really cut to the chase now. So that if we follow on down, the next it shows. No, John, don't you move. Just move our eyes. Okay. On the second from the above line, it shows February, and then the last line it shows March. And again, these evidence sales, it's a little difficult, is it not, to derive from these numbers when the actual production occurred?
It would depend on the sell date, what day they sold it. If you're assuming that production sold in March was from February production, with it being relatively the same amount of production sales as the February sales for only 6 days in February, then that would be a lot of production sold in 6 days. If you were going to assume that they stopped producing on the 6th of February when they sold 138 barrels the day or the month prior and sold 128 for February in 6 days, if that's how you were going to assume the sales were.
Well, I think all your conclusions are quite fair if your underlying assumptions are correct.
Correct.
Okay. One point I'm getting at is it possible that some of this, that any of this production could have been produced? I'm not saying it was, okay. I'm giving the operator some benefit of the doubt by the hypothetical I'm presenting here. I'll admit it. But is it possible that some of this production, for the very reasons you stated, that you'd have basically what appears to be a month's worth of production within 6 days? That would seem improbable for sure. But is it even possible that some of this production, because we're talking about sales,
Correct,
not actual production,
right?
that some of the production that led to the sales occurred months prior and could have been stored in a tank?
It is possible. You can't
Yeah.
disregard that.
Yeah, I'm not trying to make something out of whole cloth here at all. I'm just saying that there are benefits and limitations to the presentation of this evidence from the survey. That's all I'm saying. That really is all I'm saying. I'm not discounting your hypothetical or your conclusions in any way. Let me check, Mr. Chair. I think that may conclude my questions. No, I do have one more question. And I think it's kind of an important one for me. It was a question again that Mr. Brock directed to you, and I want to. I'm not trying to put words in your mouth. I want you to, if I mischaracterize the facts, you restate the facts so they're correct. If I am drawing wrong inferences or conclusions, you correct me there.
Okay.
But it appears to me that we had, and we've talked about this within the confines certainly of Mr. Brock's cross-examination of you, that in dockets number 23, 33, 23-3330 and 23-3343, that BDH Resources has been penalized $10,000 for operating these wells, and its license has been revoked. Is that correct?
I don't know the current status of BHD Resources license. I do see the penalty that Brock pointed out that stated they were getting a penalty of 10,000. So I can't disagree with that.
Okay. And I realized that you have also qualified your answer by the limits of your knowledge too, have you not?
I have. I do not do any kind of penalty recommendations or orders.
Yeah, I think that's very fair. And Mr. Brock has certainly made reference in his cross-examination and the foundations he laid for his questions that we do have a default order. That's that 23-3343 that we've been asked to take administrative notice of, and it's dated December 5th, 2023. And if I go back to the footnote number 1 of the document that was provided by the staff to us this morning. And maybe we should bring that up. Bear with me again, John. Yeah, John, it's the proposed default order that was provided by the staff to us this morning.
Okay, one moment.
23-3343. Just the first page. If you would, if you can capture that entire page on the screen and enlarge it as large as you can for us. Can you see that, Julie?
I can.
It's a little hard to see. John, let's, first of all, before we go, my next question for you, Julie, would be, this appears to be, does it not, a proposed default order that's directed to BHD Resources LLC. Is that correct?
That's what I read.
Right. Now, John, scan down to footnote number 1 at the bottom of that page and enlarge it. That's fine. Can you see that, Julie?
I can.
Footnote number 1, and I will read what footnote number 1 says in pertinent part. It says staff identified the wells located on the Berry, Collins, Funk, Headley, McClaskey, Weisbach leases as listed on the transfer of operator T1 forms dated February 3rd, 2023, and then it references the docket. Are those not basically the same leases and wells that are before us this morning under the penalty order directed to Haz Petroleum?
Yes. I believe so.
All right. Julie, thank you so much for your, you can take down the screen share if you would, John. Julie, thank you so much for your indulgence in my questions. I appreciate the candor of your answers as well. And I have no further questions for this witness.
All
Thank you,
right,
sir.
thank you, Commissioner Keen. Commissioner Keither, do you have any questions?
No.
All right, and I don't believe I have any questions. Any ground I would have covered was comprehensively covered by Commissioner Keen. So at this time, we will turn to Mr. Marsh. Do you have any redirect?
Yes, thank you, Chair French. Julie, did I hear you correctly earlier that staff tried to call Haas first when it saw wells in operation on its license or on its leases?
Yes, I believe Mr. Dealing tried to call, and I can't tell you who it was. I can't speak to that. It was his cell phone first, and there was no answer. I don't recall that there was an answering machine either. So we then turned to reaching out to BHD.
Well, and is Ben Harrell also an employee of Haas Petroleum?
That is my understanding. Yes.
So is it normal for staff to contact an operator's field staff to address compliance issues?
It is normal.
And regardless, is an operator responsible for the wells on its license?
They are.
And these wells were these wells under Haas's license?
They were.
And Julie, you're only in District 3, correct?
Correct.
Okay, I know Mr. Brock asked you some questions about if you knew of any other instances where an operator was penalized for operating while there was a T1 pending. I mean, would you have any reason to know of any such instances?
I would not.
Okay, thank you. I think that covers all of my questions.
All right, thank you. I don't know that we plowed any ground that Mr. Brock would need any recross on unless you want to wave your hand at me.
I have I promise I won't take very long, but I have just a few things.
I'll allow just a very short
Just
recross.
three questions is all, or three topics. The first one is not a question, but more of a request. Commissioner Keen made reference to the T1s. They were marked as Haas Exhibit KCC-1. I know it's kind of untypical for me to ask that that be admitted, but since we were making reference to it, I would like for that to be admitted into the record and, just for clarity purposes. I don't have any questions about it.
Yeah, Commissioner Keen obviously made reference. I think there was some foundation laid for relevance, but let me ask Mr. Marsh, do you have any objection?
No objections.
Okay, we will admit that is an exhibit. And you said it was marked as Haas 1?
I thought it said Haas Exhibit KCC-1, but I don't know that I have that printed out.
It's exhibit KCC-1.
Oh, okay.
Yeah.
It was going to be a cross-examination exhibit.
KCC 1.
Yes.
Yeah, okay. Yeah, that's right. Okay, just wanted to make sure that's clear for the record. KCC 1 is admitted then.
Okay, I'm going to share my screen real quick again. So just to make this really quick, this is a field report, one of the field reports from the penalty order in this docket. Do you concede that?
I do.
Okay. Earlier when Mr. Marsh was asking you questions, he asked you about Mr. Harrell's employment with Haas Petroleum and whether it was common to contact a field representative. In this paragraph, doesn't it say contact Ben Harrell with BHD Resources?
It does say that. Yes, we had record of the T1s knowing that was his company.
Okay. And would you agree there's no references in here to contacting him as a field representative for Haas Petroleum?
It is not stated that way.
And if I told you that Ben Harrell was not employed by Haas Petroleum in March of 2023, would you have any reason to dispute that?
I would not have any knowledge otherwise.
The last question is just really simple as it relates to KGS records. I'd ask the commission to take administrative notice of Kansas Court of Appeals case. It's called Drill Baby Drill versus Adamson. It's an unpublished case. The Pacific Reporter is 409 P3D 874.
Yeah, we'll take notice of that.
Just by way of short explanation, the court found that the KGS records were supplied by a third party. KGS cannot and doesn't certify the accuracy of them, and they're not admissible into evidence. Just a quick summary. It's a long case. That's the only issue that I'm asking.
Very good. And we'll have our counsel take a look at it.
Okay. Quick question for you, Mrs. Schaefer, on the KGS records. You had indicated that those records showed sales of oil, not production of oil.
Yes.
Is that true? And did you find records when you inspected these leases, you found BHD Resources producing them, correct?
Well, there's no indication or signage, but that's from all indication with the T1 transfer and speaking with Ben Harrell that day, not me personally, Mr. Dealing did. He was telling us that he was producing.
And is there any record in those KGS records that you attached that would reflect the production that BHD Resources was performing when you inspected the leases?
He could not. Those wells were not in his name or in his license number, so he couldn't sell any.
And I guess that kind of that's exactly where I'm going with it. Because the KCC didn't approve the T1s, it didn't update their records. If the KGS gets their information in terms of the operator from the KCC, doesn't it have a trickle down effect to make their records incorrect as well?
It would, but in that regard, those wells were supposed to be shut in until the transfer was complete.
I understand. I guess I'm just for the point that the practice of not approving them has potentially further reaching consequences than only between the current and past operator. Would you agree with that?
I would.
Okay, those are the only questions that I had. Thank you for your indulgence.
Thanks, Mr.
Sir.
Brock. And since we did allow a little extra recross, Mr. Marsh, do you have any redirect that you would like to pursue?
Maybe just one question for clarification. Julie, were the wells in operation whenever you conducted your lease inspection on March 24th, 2023?
They were.
Thank you. That covers it.
Okay.
All right. I believe we have come to the end of your examination, Ms. Schaefer. We appreciate your time, and you may virtually step down.
Thank you.
At this time, I'm going to give everybody a 10-minute break. Go refill your coffee, take a bathroom break, whatever you need to do. So we will return at 10:40. I do want to state my intention. We've only got one witness left. It's my intention that we're going to complete this by lunchtime. Now, whether lunch is at noon or at 12:30 or whenever it is, I am hoping that we can wrap up by midday. So please keep that in mind. With that, we are now in recess to return at 10:40. We're off the record. All right, welcome back, everybody. Just checking to see that we've got everyone. I see council, I see Commissioner Keen, Commissioner Keither may or may not be back yet. We'll give just a minute for Commissioner Keither to return. All right, it looks like we have Commissioner Keither, but we may, we've got our witness back. All right. All right, it looks like we do have everybody. So at this point, we are now back on the record in the hearing for this docket, and we are ready for Mr. Brock to call his witness. Go ahead, Mr. Brock.
We would call Rhonda Epps.
Good morning, Miss Epps. And you are on mute. Are you able to unmute?
All right, how's that?
Very good. All right, if you would please raise your right hand. Do you swear or affirm the testimony you will give today is the truth, the whole truth, and nothing but the truth?
I do.
All right, Mr. Brock.
Can you please state your name and business address for the record?
Rhonda Epps, business address is Post Office Box 8326, Prairie Village, Kansas 66208.
And by whom are you employed as it relates to this docket?
That would be Hospitrolium.
And are you the same Rhonda Epps that caused to be filed pre-filed testimony consisting of 4 pages on August 17th, 2023?
Yes.
Do you have any changes or corrections to that testimony?
I do not.
And if I asked you the questions contained in that pre-filed testimony today, now that you're under oath, would your answers be the same?
Yes, they would.
I'd move for the admission of the pre-filed testimony of Rhonda Epps filed on August 17th, 2023, consisting of 4 pages.
No objections.
Hearing no objections, the referenced testimony will be admitted.
We tender the witness for cross-examination, Chairman.
All right, thank you, Mr. Brock. Mr. Marsh, the witness is yours.
Thank you, Chair French. Good morning, Ms. Epps.
Morning.
Can you hear me okay?
I can.
Good. Ms. Epps, I have a few questions just based off of your testimony. I think I'm going to start with page 1, lines 7 through 9 of your testimony. And there you state that Haas has filed appropriate notice of transfer of operator responsibility form T1s with the commission. Is that correct?
Yes.
And I believe we've previously admitted those T1s into the formal record. Just want to share my screen real quick. Okay, can everybody see? This is the letter, and then this is just like an example of the T1s. This is for the Weisbeck lease, is that correct?
Mr. Marsh, you may need to zoom in a bit. We can
Yes.
see the documents, but they're very small.
Okay, is that better?
Yes, the effective date, yes. Weisbeck. Paperwork complete. Yeah, that's correct.
Okay,
Sent
and
to you
is
on
this,
the 1st of February and you received on the 3rd of February.
is this your signature on the T1?
That is.
And would you agree with me that the rest of the T1s submitted were for the other leases are virtually the same?
I would agree.
Okay, and the title says request for change of operator, transfer of injection or surface permit. Is that correct?
It says request for change of operator, transfer of injection or surface pit permit. That is correct.
Okay. Now, the commission requires legal documentation such as a copy of the lease assignment, bill of sale, or other legal documentation indicating the new operator has the right to operate the lease to be attached to the T1 form, correct?
I do not know if all of what you just said is correct. I do know that we sent in the request for change of operator, indicated all of the said leases that would be attached to that change, and as well as the division of interest. We sent that over to you. So that is what we sent. We did not receive anything from you saying that there was anything missing from those filings.
Okay, I'm gonna share my screen real quick. This is from the Kansas Corporation Commission website. I'm gonna read this out loud for the record, and please let me know if I read it incorrectly. Request for change of operator form, parentheses, T-1, parentheses, available on Colar beginning March 1st, 2017. Did I read that correctly?
Looks like you read that correctly.
And then I'm going to skip down to the fourth paragraph, and it says filing via Kohler requires both the current and lost operator to sign the T1 on Kohler before the T1 can be submitted. A copy of the lease assignment, bill of sale, or other legal documentation indicating the new operator has the right to operate the lease must be attached to the Kohler filing. Did I read that correctly?
You read that correctly.
Okay, I would ask that the commission take administrative notice of this webpage.
Any
I'm
objection?
sorry, but I do have to object to that. That's not a rule or regulation, or, I mean, I guess I don't that the webpage exists, but in terms of it having any authoritative value at all, I object on that basis.
So if there's not objection that this is an accurate representation of the commission's website, I mean, we will take notice that it is the website, but Mr. Brock, your comments as to the relevance are noted.
Similarly, on the Kohler website, this is the home page. Are you familiar with the Kohler website, Ms. Epps?
The website that the website that you that your department actually blocked us from using, is that the website you're talking about?
Are you familiar with the Kohler website?
Are you talking about the Kohler website that your office blocked us from using? Are we talking about the same website?
Well, I believe you had access to it for several years, so I imagine it was blocked once your license was expired. But are you familiar with the Kohler website?
I'm familiar with the Kohler website that your office blocked us from using. Yes, I am.
Okay. And would you agree with me that this looks like the homepage of that website?
Looks like it.
I'm going to scroll down. And I'm going to read this highlighted paragraph. Please let me know if I read it incorrectly. Filing via Kohler requires both the current and last operator to sign the T1 on Kohler before the T1 can be submitted. A copy of the lease assignment, bill of sale, or other legal documentation indicating the new operator has the right to operate the lease must be attached to the Kohler filing. Did I read that correctly?
Yes, filing both requires both the current and last operator to sign the T1. Does not say that both the current and last operator have exactly the same paperwork, but it does say both the current and last operator to sign the T1 on Kohler before the T1 can be submitted. We submitted our part. I do not know what the BHD submitted to you. Don't have that.
My question was if I read it correctly. Did I read it correctly?
I would say that you read it correctly.
Okay, thank you. I want to turn to page 2, lines 17 through 20 of your testimony. There you state that staff's refusal to accept the T1 forms submitted by Haas Petroleum had no legal effect, as responsibility for these wells was legally transferred with the delivery of the lease assignments, operating agreements, or other documents, correct?
Let me get back to that. What are you referencing again, please?
It's page 2, lines 17 through 20 of your testimony.
Well, it looks like I don't have an exact copy, but please repeat what you just said, and then I'll just see if I can go off of memory that that's what I actually said.
Well, and if it'll help, I'll pull up that portion of your testimony. It's not. Okay. And page 2, line 17 through 20 of your testimony, you state that staff's refusal to accept the T1 form submitted by Haas Petroleum has no legal effect, as responsibility for these wells was legally transferred with the delivery of the lease assignments, operating agreements, or other documents. Correct?
That's correct.
But there are no lease assignments, operating agreements, or other legal documents that were attached to the T1s, correct?
I do not have record of what the new operator sent to you. I only have a copy of the T1s that I sent to you for reference. That's it. I do not have any copies of any paperwork that BHD would have sent to you.
So the T1s that you submitted did not have any legal documentation attached to them, correct?
The T1s that I sent to you are just that, and you should have a copy of them.
And they did not have any legal documentation attached to them, correct?
According to what I'm looking at on screen that you received, it does not look like there was any legal documentation. And that's probably up for whatever legal documentation is. It's a little vague on what that legal documentation would be. But yes, I would say that there was no legal documentation according to what I'm looking at here.
And Ben Harrell was a field superintendent for Haas Petroleum, correct?
Ben Harrell, when he was employed by Haas Petroleum, worked for us.
As a field superintendent?
Are you talking about his last position with us or what he started out with us?
Let's go with the last position.
He was later, yes. Once we relieved our other field supervisor, we did put him in that position to help us try to get everything back on board.
Okay. I'm going to pull up what I've marked as exhibit KCC-2. Ms. Epps, does the top of this page say docket number 23-CONS-3330-CSHO?
I think we can all see that that is exactly what the docket says.
And docket number 23-CONS-3343-CPEN?
Again, I think we all can see that that's exactly what it says.
Okay. And this states answers and responses of BHD Resources LLC to commission staff's first set of interrogatories and requests for production of documents. Did I read that correctly?
Again, that I believe we all can read that that's exactly what it says.
Okay. I'm going to scroll down to 2 responses.
I know that evidentiary rules are more open at the commission, but we'd object in terms of there's no foundation. This is a document submitted by someone else, is not part of an agency record. It's not a filing that the commission can take administrative notice of.
Well, and I haven't asked to admit it yet. I'm mainly using it as rebuttal at this point to statements that Ms. Epps has made in her testimony. I think it could fall under hearsay potentially, but I think it meets a hearsay exception as it's party admission.
Yeah, we'll let you continue as a rebuttal exhibit to get her responses. To the extent there's foundation laid, we can discuss admission of the document.
Okay, thank you, Chair French. Ms. Epps, I'm going to highlight a portion of that document, specifically 14, request number 14, and the response. It says, please provide all operating agreements or similar documents of which Mr. Harrell and or BHD Resources have been included. The response, BHD Resources does not recall entering into any written operating agreements, although it is possible that very basic written operating agreements may have been executed in order to accompany the T1s which were filed. Did I read that correctly?
We can, if we're all able to actually read, we can all see what you have on the screen.
I'm just asking you that if I read it correctly.
According to the English language, you are reading correctly, yes.
And response 15, it asks to please provide all lease agreements or similar documents of which Mr. Harrell and or BHD Resources have been included. And the response was not applicable, correct?
According to the English language, it says response NA per Mr. Harrell's testimony.
I want to flip back to exhibit KCC-1. And the first page of that exhibit is a letter that you sent to commission staff, correct?
The first page is what? I'm sorry?
A letter that you sent to commission staff regarding the T1s from Hospitralium to BHD Resources, correct?
Yes, that is correct.
And in that letter, you state that all working interest owners of the attached leases agree to make the following change, and that following change is the new operator is BHD Resources.
That is what I wrote.
And who are the working interest owners of those leases?
There were a couple. Let me go back and look at those. You should have a copy of that yourself.
I do. I guess maybe a more direct question is Mormeg LLC a working interest operator for each of those leases?
Not necessarily, no.
Which leases are they not a working interest owner of?
Let me go back and look at that. And again, are you asking me questions that you actually have a copy of, or that I believe the working interest owners are attached to that?
And attaches the division of interest order listing.
Okay, yeah. Yes.
So for the Weiss Raff lease, Mormeg LLC is a working interest owner, correct?
That appears to be so, yes.
And then for the Funk lease, Mormeg is also a working interest owner, correct?
That is correct.
And is this PO box for Mormeg LLC the same PO box as the one that you stated as your business address?
Both Mormeg and Hospitralium have the same mailing address, although very separate entities. They do share the same mailing address.
Correct. And isn't Mark Haas the owner of Mormeg LLC?
Yes, he is.
Would you agree with me that Mormeg is a working interest holder of each of the leases?
We just established that already. You just went through that and you pointed out to me on the division of interest. You've already established that.
Well, I pointed out two of them earlier. You seemed to think that they were not a working interest owner of each of the leases. I'm happy to go through each one, but just for the sake of efficiency, excuse me, I was seeing if you'd be willing to agree that Mormeg is a working interest holder for each of the leases.
Well, if we were actually trying to be efficient, we probably would have just stuck with the paperwork that you have here in place. I can clearly read, you can read it, and everyone on board with this, we're all capable of reading. It does say that Mormeg is a working interest owner.
Okay. And Mark Haas owns Mormeg LLC, correct?
Mark Haas owns Mormeg LLC. That is correct.
And his signature is not on this letter, correct?
The letter was written from me on behalf of Haas Petroleum. I am the only signer on that. You can clearly see that at the bottom of the page.
Okay. Think I'm almost done. I think the next thing I'm going to do is pull up the proposed default order in dockets 23 CONS 33 CSHO and docket number 23 CONS 3343 CPEN.
Mr. Marsh, did you intend to offer the discovery response document as an exhibit?
I mean, I would if the commission would allow it. I agree that I don't know that the foundation is necessarily there or not. I do think it's helpful as far as a reference of getting a record of there is no operating or lease agreements that were attached to the T1s.
You know, I've reviewed it. Mr. Brock, I'm willing to hear your response. I have reviewed it. It's signed by Mr. Brock. So it appears to me that it's verified. I think the question may be relevance, and that is something the commission could take under advisement. So I'm sort of inclined to admit it as an exhibit and let us, you know, give it whatever weight it's due, and perhaps we don't find it's due any weight, but that's my inclination. Mr. Brock, before I make a ruling, I will allow you to respond.
Yeah, and I mean, like I said earlier, I know the rules of evidence are lax. You know, even though it's verified, it certainly is hearsay. I also I don't think there's any foundation laid for it because the person who verified it or answered the questions isn't a witness. But I understand where you're at, so I'm not trying to be unreasonable about it, but I'd sure like to have the objections noted.
We will note your objections just in the interest of having a full record. I am going to admit it, and as I said, we'll examine it. We'll give it the weight it's due, given the fact that it wasn't necessarily subject to any cross-examination, but because it is verified by the counsel for both parties, I think it makes sense that we do have verification of the document. So I'm going to go ahead and admit it into the record. And Kelsey, what is that? I don't know if that had a label on it. Is it KCC Exhibit 2?
I believe so. I think it's exhibit KCC-2.
Okay. KCC 2 is admitted with the objections of Mr. Brock noted. Go ahead, Mr. Marsh.
Thank you, Chair French. I have pulled up a proposed default order from the dockets that I previously mentioned, 23-3330 and 23-3343. I'd ask that the commission take administrative notice of this document if they haven't already.
Any objection?
No.
We will take administrative notice of these documents.
Ms. Epps, is it correct that the purpose of this docket would be to consider whether operator's license should be, and whenever it's an operator, BHD's license should be revoked, and whether the wells should be transferred to BHD's license?
Again, if you're asking me to agree to what's written in paragraph 1, that is what it says.
And the specific wells are mentioned in footnote 1, or the leases are identified in footnote 1 as the Berry, Collins, Funk, Headley, McClaskey, and Weisbeck leases.
That's what it says. Excuse me.
I'm going to scroll down to ordering clause B. And it states that if this proposed default order becomes effective, then this matter shall be completed as follows. 1, operator's license shall be revoked as of the date this order is effective. 2, the wells described in footnote 1 shall not be transferred to operator's license. 3, the penalty order and docket 3343 shall become effective and final. Is that correct?
Yes, operator's license being BHD. That's the operator that we're talking about. The
It is.
wells described in footnote 1 shall not be transferred to BHD. And the penalty order shall become effective and final. Yes, that's what it says.
Thank you. I guess one last question that I would have is, I know Mr. Brock, during his cross-examination of Ms. Julie Schaefer, asked if she was aware of any instances where an operator has been penalized while T1 is pending. Ms. Epps, are you aware of any such instances?
I'm not. I'm only aware of what you've tried to penalize us for. In fact, we've had operators that we've transferred other wells to that have operated for more than 12 months and have never received any type of penalty order. In fact, it took you more than 12 months to even approve some of those T1s without any type of penalty to the operator or us, for that matter.
Did you conduct any research to see if there are other dockets out there?
I did. Now, whether or not I had any access to dockets that maybe I just can find. I'm not a researcher. I'm certainly not a researcher of law, but I could not find any with searching that I did.
Where did you search?
Numerous places.
Care to specify what these numerous places were?
I do not. But if you have access to records to show that you've penalized others, I'm happy to see them, happy to look over them. I'd like to probably know if there were, other people that had the same similar treatment.
Thank you. I think that concludes my cross-examination, Chair French.
All right, thank you, Mr. Marsh. Let's turn to commissioner questions. Commissioner Keen, do you have any questions of this witness?
Yes, thank you. I do, Chair French. One question for the chair before I proceed, if I might. We just recently discussed the proposed default order. Has it been admitted?
I believe we did take notice of that order. Mr. Marsh, do you recall if that was one of the documents we took notice of?
I'm sorry, I zoned out there for a second. Which document?
It was the proposed default order?
Yes, I believe we did.
So we don't have an exhibit number, but we've taken reference to it then, basically. Okay, I got it. All right. Good morning, Ms. Epps.
Good morning.
A few questions for me. Who were the owners of Haas Petroleum LLC in the February through March 2023 timeframe?
The owners of Haas Petroleum would have been Mark Haas.
Was he a 100% owner?
I believe I also had some amount of ownership, although not completely vested, but Mark Haas was the 100% vested ownership of Haas Petroleum.
Yep. All right. Who are the present owners of Haas Petroleum LLC?
That would still be Mark Haas.
Same situation, 100% vested.
That is correct.
Okay. What role, if any, does Mark Haas, as the 100% owner, play in the operations of Haas Petroleum?
Haas Petroleum is no longer operating, so he has zero role in Haas Petroleum operating.
Okay. That'll lead me to the next question. You may have answered it in part, but I want to make sure that it's on the record clearly. What is the scope of Haas Petroleum's activities since February of 2023 through today?
Haas Petroleum is no longer operating. Petroleum is basically defunct. We are no longer operating as a company that formerly operated in the oil and gas market here.
Okay. Just to follow on to that very briefly, was Haas Petroleum a Kansas LLC?
Haas Petroleum, yes, was a Kansas LLC.
So what you're saying is that it has not, and it has no intention of filing the annual report to maintain its status as an entity, operating or not. Is that correct?
It will not be filing to continue operating. That is correct.
Okay, fair enough. The reason I was asking the chair at the outset and prior to my beginning of this cross of you was that if we were to turn back, and I'm not asking we screen share unless you think it's necessary, but a part of what was contained within that proposed default order as an exhibit were these various division orders. Do you recall that?
Yes, I do.
And I don't know if all, not really, doesn't really matter, but several do refer to an entity called Mormeg LLC. And I think you've already stated that entity was 100% owned by Mark Haas. Is that correct?
That is what I stated.
What has been the relationship between Mormeg LLC and Haas Petroleum LLC?
I am not employed by Mormeg LLC, so I cannot answer that for you.
Can you answer whether or not there's a relationship of any sort between the two entities, you being the controller, the primary manager of one of them?
There is no relationship as it pertains to this docket that we're here to discuss today.
Is there any other relationship? Any other business? It's the business relationship. That's what I'm looking at.
No, there's no business relationship. The only relationship that there is clearly showing that Mormeg is a division interest owner.
Change the line of questioning here just a bit. I believe it's fair to state, I think it's already on the record, but we'll restate it just as foundation here, that you were the president and CEO of Haas Petroleum on the dates the T1s were executed and submitted. Isn't that correct?
Sure, correct.
Okay. Subsequent to your submission of these T1s, did you have any contact with the KCC staff regarding the processing of these T1s?
Are you talking before February 1st when the letter was dated?
Well, I'm not trying to trick you here in the slightest. All I'm asking very straightforwardly is, subsequent to when you submitted the T1s to the commission, which appears to be in early February of 2023, if I'm following the chain of events here. All I'm asking you is, did you, subsequent to that submission, did you have any contact with KCC staff regarding the processing of those T1s?
I would say yes. I probably had a phone call or two to the department that handles those transfers.
And what was the essence of that communication back and forth?
Basically, they could not give me an answer on why those have not been processed, other than to refer me to the legal department. I would have to talk to Mr. Kelsey.
And did you do that?
I left him several messages.
Did you ultimately talk to him?
Never returned them. No.
A different line of questioning slightly, but in the same vein. Did you receive any subsequent to your filing of the T1s? Did you receive any subsequent request from the KCC for any additional documentation that evidenced the transfer of the leases and the wells from Hess Petroleum to BHD?
No, I'm not aware that we received any additional inquiries, requests. No.
No subsequent requests for additional documentation from the commission of
No,
any sort. Is that what you're saying?
that is what I'm saying.
Okay. Again, I don't intend this to be a trick question in any respect, but we have a lot of dates that are kind of floating around here in the early months, basically January and February of 2023. So I guess what I'm asking you very straightforwardly is, in your opinion, on what date did BHD and Mr. Harold take on or assume ownership or control over the leases and wells that are here in question?
I can't really answer that because whether that is a straightforward question, but I don't have any information as far as the actual timeline that he physically took them over. I don't have that answer.
Okay. The reason I'm asking that, and I'm trying to be very straightforward here, is that we could have several dates that are in play. We could have date of assignment. We could have dates of transfers on the books of a first purchaser, conceivably. We could have whatever other supplemental legal documentation was involved. All of these things could be in play, but there was some date certain along that path. I'm guessing it's in January or February of 2023 when Mr. Harold assumed not only ownership but control over these leases and wells, and that's the date I'm looking for from you.
I don't know that I can really answer that with any certainty. I know that the T1, according to the T1, that was actually completed, I believe, on the 30th, according to that form. The signature was there. I know that it was mailed to you and received on the 3rd. That's all the information that I have.
Okay. Yeah, I think I appreciate that answer, because it highlights why I'm asking the question because of the number of dates that we have in they're in play. So let me ask as a very brief follow-up then. Subsequent to this date, whichever date it might be, whether it's the 30th, whether it's the 3rd, whether it's the 1st, whatever it is, what role did Hess Petroleum play in guiding or directing, directly or indirectly, the field operations of these leases and wells?
What role did Hess Petroleum play in the guiding of BHD operating the wells?
Yeah, let me ask the question again, in fairness to you. It's a long question. I didn't mean to make the sentence compound to trick you. My question is simply this: subsequent to the date of transfer, whatever specific, not the date of, but the date that Mr. Harold actually assumed ownership, control over the field operations of these leases and wells. Subsequent to that date, what role did Hess Petroleum play in either guiding or directing, either directly or indirectly, the field operations of these leases and wells?
0.
Okay. Bear with me a moment. One other question. And for that, we need to go to, again, to the rebuttal. And John, you can help do a screen share here. We'll go back to Julie Schaefer's rebuttal testimony, please. In particular, what I want to do is bring up once again the first page of the exhibit, if you would. That's JS1, page 1 of 20. Yes, Ms. Epps, can you see this on the screen?
I can.
This pertains to the Berry lease. There are, as you may recall, there were, in conjunction with this rebuttal testimony, there were several other Kansas Geological Survey oil and gas lease production documents for other leases that are before us this morning in a similar vein, where it shows a lot of information. Do you see at the top where it shows the Berry lease? It identifies the operator as Haas Petroleum. Do you see that?
I do.
Okay. If we could scan down now, John, staying on the same, if we scan down to page 5, page 5, that's fine. Right there. Can you see that, Ms. Ann?
I can.
Okay. This is page 5. This is a continuation of that lease production sale history, on the Kansas Geological website for the Berry lease. And if you will look at the very bottom here, in particular, I guess we'll focus on the bottom 2 lines. The one that is for oil sales in February of 2023, that's the second line from the bottom. Do you see that?
I do.
And it shows sales of 138.82 barrels. Is that correct?
Yes, that's what it shows.
To CVR Supply and Trading. Is that correct?
That's correct.
Okay, and then we move down to the bottom line. It shows March of 2023 sales in the amount of 128.45 barrels. Do you see that?
I do.
That's also to the first purchaser, which is CVR Supply and Trading. Is that correct?
Yes, that's what it says.
I want to ask you a very open-ended question here. And you can answer it to the best of your knowledge. Since we have a date here of February 6th, 2023, beyond which Haas Petroleum is saying it had no ownership or control over the leases, since the KGS website here shows that Haas is the operator, and it shows that we have oil sales in both February and March, which intersect that critical date of February 6th, 2023. How can, I'm asking for your help, how can we reconcile that and conclude that Haas did not operate or sell the wells and leases in question?
Well, I think you can conclude that by just showing the just because it shows on that site that we are still the operator, I would imagine is a little bit of a catch up as far as paperwork on their end, just like it's catch up on paperwork on your end with those T1s not having been transferred. Clearly, we submitted our paperwork. You received that paperwork. You have evidence that we were not the operator. When your field staff went out, they saw BHD. They did not see Haas Petroleum. They did not see any Haas Petroleum employees. That's how you know that we were not operating.
Okay. If I represented that as my last question, I'm glad everybody, because I do have one additional question. This will be my last question unless something you say triggers another. What consideration or payment did Haas receive from BHD for the transfer of the pertinent leases and wells from Haas to BHD?
Repeat that question, please.
Surely. What consideration, and I'm looking here for a sale price. That's what I mean by that. What consideration or payment did Haas Petroleum receive from BHD Resources for the transfer of the pertinent leases and wells from Haas to BHD?
I can't answer that. Haas Petroleum was only the operator. Their operators don't necessarily mean that they own those leases. So I don't have an answer to that. We're the operator. I worked for the operator.
And as operator, you have no knowledge, is this your testimony? You have no knowledge of the sales price to BHD and Mr. Harrell from the company for which you are the CEO and chief executive officer. Do I understand that correctly?
You're asking me what is the sales price for those leases. Haas Petroleum was the operator of said leases. Haas Petroleum did not own the leases. So yes, you are understanding me correctly. I do not have the information with regard to what the sale purchase was. If there was a sale purchase, what the amount was. We were the operator. We did not own the leases.
Okay, very good. Ms. Epps, thank you for your indulgence to my questions. I have no further questions at this time of this witness. Thank you.
All right, thank you, Commissioner Keen. Commissioner Keither, any questions?
Yes, I do. Ms. Epps, you referred to follow-up phone calls and said you didn't get any answers. Do you have dates of those phone calls? You seem to be dancing around dates.
I do not have dates.
No records?
I do not have dates in front of me.
In front of you, okay. Can you find them?
That would probably be a difficult task at this point. I suppose if you want to reconvene and allow me some time to find those, it's possible.
Well, I'm just sort of interested in the timing of them because we are talking around specific dates, and I just was wondering if you off the top of your head, you don't have to go back in, but just
I was should have been a very familiar number coming across the screen. I called, I've emailed. I think they oftentimes knew just when I was calling in, just the phone number showing up. So, but I don't have those dates in front of me.
But you don't have dates. Okay. All right. Thank you.
All right, nothing further, Commissioner Keither. The only questions I'd have, John, would it be possible to pull up the last document we had pulled up, which was the KGS records? And Ms. Epps, I don't know if you're able to answer. Go down to the bottom, John. I don't know if you're able to answer these questions, but we were talking about that first, that Haas was still listed as the operator on these KGS records. Do you know where KGS gets that operator information from? Do they pull that from who KCC has listed, or do they get it somewhere else independently? And maybe you don't know.
I cannot answer that question. I don't work for that entity, so yeah. I don't know how they pull that information.
Okay, I mean, I'm obviously just trying to get it. Is it a circular thing where if we haven't changed it, then they just haven't changed it? I didn't know if it came from somewhere independent, so that's okay. The other question I have is, obviously we're talking about an alleged change in operator here at February, I think we said 6th. And I do see that the, who we're selling to is changing, although would be an affiliate. It started out as, for a long time, it looks like Haas was selling to Coffeyville Resources Refining and Marketing. And then it changes to CVR Supply and Trading. So I'm assuming that's, it's all CVR. It's an affiliate, but it's a slightly different entity. Would you know if, because you obviously dealt with CRRM, do you know if there was a name change there, or do you know if that's a different entity? Would CVR Supply and Trading be somebody that Haas ever sold to? Do you have any context to add on why the purchaser changed?
From my understanding, CBR and Copyville Resources are one and the same, I believe.
So you don't know what this new CVR Supply and Trading is and why there would be a different entity there.
I bet we could probably ask Google.
I guess what I'm getting at here is if there was a change in operator, it seems possible they would be selling to somebody different. And so I'm trying to suss out whether that's actually a different entity. But it doesn't sound like, it sounds like you'd be as qualified as I am to Google it, is what you're
Right,
saying.
yeah,
So,
yeah.
okay. All right. Those were the only questions I had. John, you can take down the screen share. All right. I think we are ready for redirect. Mr. Brock?
Thank you, Mr. Chairman. In terms of the T1s that you filed on February the 3rd that were made effective on February the 1st, do you recall having received any notice, any call, any letters, or any documents whatsoever between February 1st and today at this hearing when the staff claimed that they didn't process the T1s because they didn't have copies of assignments or operating agreements?
No.
And so even though those were filed a little over a year ago, today at this hearing is the first that you've heard any inference that they weren't approved because there wasn't documents attached to them. Is that correct?
That is correct.
Was Ben Harrell an employee of Haas Petroleum after March, or I'm sorry, on March 24th, 2023, when these wells were found to be operating?
He was not.
Did Haas Petroleum have to lay off all of its employees when it had to cease operating?
Yes, that is correct. All employees were laid off.
Just to flesh out some of what you talked about, you were clarifying that Haas Petroleum was an operator. Is it possible and common that entities operate leases that they don't own?
Sure. I mean, operating companies do just that. They operate the leases, but it doesn't necessarily, it's not an indicator that they own those leases. So it's very common that you just have operators that just operate leases for people that own said leases.
And in terms of Haas Petroleum's business operations since the entire time that you were affiliated with them until they went out of business on February the 6th, 2023, was it predominantly Haas Petroleum's business that they were an operator and they didn't own leases?
That's correct. Haas Petroleum was just that, an operator. Haas Petroleum owned no leases.
So they never owned any leases.
That is correct.
And so were they just paid on a contract basis by the owners to operate the leases?
That is correct.
And did they issue monthly joint interest billings to each working interest owner?
Yes. For the most part, most of those owners actually oftentimes received funds from the actual oil producers themselves, so the actual oil purchasers.
And would a Haas Petroleum have billed joint interest billings to Mormeg during that time too?
Yes.
And just to be clear, was Mormeg in operation for many years? Or I shouldn't use the word in operation because we've made a distinction between operator and owner. Did Mormeg exist and own leases for many years before February of 2023?
Yes, I think 30+ years.
And Mormeg wasn't an operator. Is that correct?
Mormeg, that is correct. Mormeg was not an operator.
They just,
According,
Mormeg just paid other entities to operate, including Haas.
that is correct.
And so in terms of consideration between Haas and BHD, was there anything sold from Haas to BHD? Was there any property interest that Haas had that was transferred to BHD?
Are you talking about? Can you be more specific? I'm sorry.
I'm just trying to flesh out one of the questions to get an answer. So you had testified that Mormeg was the owner of these leases when Haas Petroleum was the operator. Is that correct?
Correct.
Or at least a part owner. I don't mean to generalize, but at least a part owner. And Mormeg was still that same percentage of ownership when BHD operated them. Is that correct?
As far as I know, I worked separately from Mormeg, so I don't, I'm not employed by Mormeg, so I don't have all of their information.
I understand. I'm just trying to flesh out the difference between an owner and an operator. And so
Okay.
as I'm understanding it, Haas Petroleum received its income by being paid by working interest owners to operate leases. Is that correct?
That is correct.
So Haas Petroleum didn't own wells. It didn't receive production from wells. It was paid by working interest owners. Is that correct?
Yes, that's correct.
And so when operations were transferred to BHD, did Haas Petroleum own any interests that were transferred to BHD? Or was it
Yes.
just operatorship that was transferred?
Just operatorship that was transferred.
And I know you said it in your pre-filed testimony, but just to clarify, did Haas Petroleum produce any oil from any leases after February 6th, 2023?
No. We produced no oil. We had no employees at the time. I certainly wasn't out there producing oil. So no employees. We weren't out there in the field. We did absolutely nothing. We did everything that we were supposed to do, which was get those, wells shut in according to what the state had us mandated to do, and we did just that.
No further questions.
All right. I did allow recross for the last witness, so I will at least offer the opportunity. Mr. Marsh, do you have anything you need to follow up on?
I don't believe I have anything, Chair French.
That's great. All right. Since we don't have any recross, no redirect, I don't see any commissioners trying to get my attention. Ms. Epps, I think that means you may step down virtually. Thank you so much for your testimony today.
Sure.
Let me check my script here, see where we're at, if we need anything additional. We have concluded the witness examination. I don't know if the parties talked about closing statements or briefing, but let me ask at this time, we'll move to closing statements if the parties would like to make them. And Mr. Brock, would you like to make a closing statement?
Yes, I would like to make a closing statement and no briefing.
Okay, very good. Go ahead.
Oh, I'm sorry. I was waiting
Sorry,
for you
we
to
are
ask
ready for
Kelsey.
closing statements.
I apologize. So with my opening statement, I started very broad. Now we've gone through the facts of this docket. I'd like to tie that back in together and explain why I did that. In this particular docket, the evidence isn't in dispute. It's agreed on that Haas Petroleum didn't conduct any physical operations after the commission ordered them not to. It's agreed on that there was no field work done, that any of the activities in these regulations were not done after they were ordered to shut down. if the commission staff, if their position would be enforced that if an operator transfers responsibility, but then the staff has not approved the T1, this commission will have to be prepared to penalize all operators that transfer their wells, and then operations are assumed by the new owner before staff processes the T1. So far, Haas Petroleum is the only operator, and BHD is the only operator that the commission has done that to. And frankly, I don't think the commission wants to do that to other operators. And so I'm just pointing that out, that if they're not, that is desperate treatment among the various operators. Pulling it back to the beginning in this purpose, what's happened here is the regulations are being changed through administrative procedure or through adjudicative proceedings. And what that's resulted in these enforcement actions is I'd just like to run through the effects. You saw some of them in this docket. There was an attorney that practiced before the commission for a lot of years. His name was Jeff Kennedy, and he had something he always would say, that the commission's regulations are comprehensive, plainly written, and detailed. And so when you're dealing with enforcement, don't think great thoughts, just enforce the darn stat or the regulation. And I always laughed, but that's what the crux of this docket is. Where it all started is 82.3.136A says that if operator responsibility is transferred, a T1, or basically notice of that transfer, shall be filed 30 days after the fact. There's all kinds of other authority that supports that. In the docket 23 CONS 3109 CPEN DB Energy docket, the commission basically found that they didn't have a problem with the staff holding these T1s and not approving them. But this is the issue. This is why I'm bringing this all up. That was an enforcement docket. That changed the practice, that changed the effect of the T1, but the regulations didn't keep up with that. It was done on that case-by-case basis, and now the effect has a whole bunch of different implications. We've showed in this docket that not only are the KCC's records not accurate now, but the Kansas Department of Revenue's records are now made inaccurate. So are the Kansas Geological Survey records not made inaccurate because the staff is not processing them. In this docket, Haas Petroleum had wells or T1s that were on file for between 2 and 3 years and were not acted upon. In this particular docket, those T1s were on file for more than a year before staff even gave a reason as to why they weren't processed. And today, at this hearing, the other effect that this is having is the point I was making with these other dockets. The commission in this docket and in the other Haas docket, the 24 CONS 3006 docket, is now issuing orders that affect these wells, vested property interest in these wells, permits granted by the commission in these wells that affect other operators. And because you're not updating your records, because the T1s are being held, those parties aren't receiving notice. That's a direct due process violation, because these orders, but for a request for hearing, would have caused other operators' wells to be shut in and permits revoked without them ever even having gotten notice that this happened. And I'm not trying to go back and argue that docket. I'm just pointing out that the commission just should be aware of it. The other things that docket does that may not have been foreseen is that there are no objective criteria for the staff to approve or deny the T1s. None. In the regulations, there are none, because it's not even due to be filed till 30 days after the fact. There's no time period in your regulations that require them to act or to approve or deny T1s within a stated time period. There's no procedure for an operator to issue a dispute if staff refuses to process the T1, which makes staff a unilateral arbiter with no criteria to simply not act on them, like they've done in this docket. There are no provisions governing notice to the past and the present operator in circumstances where a T1 has been filed but not approved. In addition, what's the effect of the industry on when you have transfers that are made but not approved for 2 years or even 2 months, what's the effect of the industry? And my only point in making all that is that that decision had sweeping implications. And in that instance, the Oil and Gas Advisory Committee was that's the commission's friend. That's enacted to raise these issues before that goes into effect. The public comment period of the rulemaking exists. That's your friend. That's enacted so that somebody raises these before they go into effect. But what's happening is staff is wanting a rule change, and so they're presented in these enforcement actions like we have today, and then the operator has to defend them, and then the commission issues an order without any participation from the industry, any notice to the industry that something's happening. It's a broad sweeping effect. That's my only point in this global practice, because this docket and others have a much broader effect than they may appear at first blush. And so I'm just trying to ask the commission to, sometimes we see lose the forest for the trees, and I'm just trying to make a clear view of the forest in this. I do agree with the commission's rationale that when a lease is transferred, that's a great time to go look at the lease, but nothing in the regulations prohibit that. Staff can inspect leases anytime they're transferred. They can issue penalty orders to the past operator, to the current operator, but you don't have to mess up the records by just holding them in abeyance and having all of these other consequences. The question that I would like for the commission to ask is, if decisions are made like this, based on whether an operator is good or bad or acted in a way they should or shouldn't have, and that if it's allowed that these rules and laws are applied differently to operators throughout the industry, whether that's by direct action of the commission or by its staff, and then if you allow the continued enforcement attempts or using these adjudicative proceedings to continue to try to change in the rulemaking process, the question would be, what kind of regulatory framework are you leaving the industry with? Because it results in these orders that don't take on this bigger picture of regulation, the outside consequences that are brought to the table through the Oil and Gas Advisory, the notice and comment, public comment period. These are big questions. And the reason that I'm bringing them up is because the legal issues in this docket in my brain or in my mind are very simple. All the staff reports indicate that BHD was operating these wells. The final order in the BHD docket says that BHD was operating those wells and penalizes them $10,000 for it. All parties agreed that Haas Petroleum was not found to have been conducting any physical operations. There's been allegations toward a common ownership being Mark Haas, but we have an entire framework, a body of law surrounding alter ego, piercing the corporate veil, and there's been no attempt whatsoever to meet that standard. There's just an allegation, well, they're owned by the same people, so we should completely disregard any separate entity status. That's not the law. That's one of the issues. I mean, that goes into the same vein. We have to be enforcing the law as it's written in these types of proceedings. The two violations that are alleged is KAR 82-3-133. In order to have violated that, Haas Petroleum would have had to been found to have produced oil after February 6th. The evidence shows that they didn't, that there's no evidence that they produced oil after that date. KAR 82-3-120, in order to have violated that, Haas Petroleum would have had to conduct drilling, completing, servicing, plugging, or physically operated a well. All the evidence indicated that none of those things were done by Haas Petroleum after February the 6th either. And so the legal issues are simple. But Haas Petroleum has been forced to defend itself in this. And if they would have allowed the commission to take default, there would have been an order shutting down all of these other operators' wells who never got notice and an opportunity to come forward and defend themselves. That's why I'm bringing up these overarching policy issues, because these things have had broad impact. And I just want the commission to see that. That's all I'm asking. I thank you for your patience. I know I've been long-winded. I'm always, I was really hesitant to maybe go as broad as I did with this, but I appreciate your indulgence very much.
Thank you, Mr. Brock. Mr. Marsh, do you have a closing statement?
I do, thank you. I know Keith touched a lot on the overarching themes or theories here, and maybe they were at play a little bit, but I also kind of wonder if this is the correct forum or not. I get that, you know, it potentially has an impact on the outcome of this hearing, but it almost seems like, you know, we bring in a lot of other dockets. I know we talked about the 24-3006 docket, which is unplugged wells on the expired license. And that docket's still currently pending, and Keith and I are trying to get things worked out there. But, you know, he also brought up the 23-3109 docket with DB Energy. And, you know, I think about that docket, and there's a few things that stuck out to me is with that docket in particular, as far as the commission having the authority to approve and deny forms, including requests for change of operator forms. And it seems like the commission also tried to make a distinguishment about transferring ownership versus transferring responsibility for a well. And then I also know, and it appears that docket was very fact specific or situation specific and was meant for just that specific scenario. And we don't necessarily, I mean, we don't have the same facts at stake here, so it kind of questions how much that docket's applicable or not. But going back to the, you know, transfer of ownership versus transferring responsibility for a well, I think staff's, you know, looking at this docket, staff's main position is that, you know, responsibility for a well is not transferred until the T1 form has been processed. And going by that, you know, Haas is going to be responsible for the actions that are taken at a well before that T1 form is completed, processed, and transferred. And, you know, as we heard here today, there's issues transferring that form because forms are required to have legal documentation in order to be transferred. And there's a reason for that. We have, you know, there's district court cases that were held that basically, hey, you know, sometimes operators aren't responsible or if wells are not transferred. And so that, I think, has led to that basically staff interpretation or policy decision, however you want to look at it, that, hey, we need legal documentation in order to process T1 forms. And I think that's really probably going to be a distinguishing factor between these T1s specifically and maybe other T1s that are out there. I know that we didn't really admit that into the record, but I think if you look at other T1s that have been filed between Haas and other operators, you're going to see that sort of legal documentation there that you don't necessarily see here at this in this specific scenario. I think that might cover about everything I needed to. I guess I'd bring up the docket 23, CONS 3343 CPN, where the commission's already decided that the T1 should not be processed and transferred, and that the T1 should remain, or the well should remain on Haas's license. And as you know, Keith mentioned during cross-examination, those wells are part of the 24-3006 order, which is, you know, so they're still considered to be Haas's wells. And I think if they're still considered to be Haas's wells and they were found in operation after they were supposed to be shut in, then Haas is still responsible for making sure or ensuring that those wells are not operated until the T1 process has been completed, or there's some, you know, official indication that, hey, these wells have been, or this other operator has the authority to use these wells. So that's, I think, the crux of staff's position, or the way the staff sees it, and tries to be a little bit more straightforward and not necessarily let's drag in all the overarching stuff as well. So thank you for your indulgence, and I appreciate your time.
All right, thank you, Mr. Marsh. So we have concluded our closing statements. I understand the parties are not requesting to file post-hearing briefs, but let me ask if there are any other post-hearing issues that need to be addressed before we conclude the hearing.
I have none.
I don't think I have any either, unless, I mean, and I'm not really a good writer, so I'm not proposing to do post-hearing briefs. The only way I would propose to do it is if the commission thought it was necessary, because it seems like there's a difference of interpretation or a difference in argument between the parties as far as what should apply.
Yeah, I will admit, I gave that some thought, while the examinations were occurring. We'll confer with our legal counsel and see if any briefing would help clarify the record, or if whether, the testimony we have, sort of on file already gives us, clarity. So we'll follow up with the parties if we need any briefing. If we do, I expect it would be quite limited. But let us confer with our counsel before we request anything. At this point, I would not expect it, but we'll update the parties if we think we need anything. All right, if there are no further issues, this does conclude our hearing in this docket, and we will close the record and adjourn. Thank you all for your participation. Have a good day.
Thank you.
Thank you. Thank you, Commissioner.